All right, they've opened up the gates, guys. We've got panelists logging in right now, 18, 19, 23, 27, 28, 30 people. People are logging on because they want to hear what you have to say. What you have to say is very important to the world and to the industry that we're in. We're up to 46 guests, 50. What I told you? I told you we would hit 50, 52, 54, 55. I mean, when I spam people, I spam them. All right. I put out the word, and every now and again I get that message. Would you please just stop emailing me? And I say, no problem. Occasionally I get a little upset, like I take it personally, but I just feel like, why couldn't you just hit the unsubscribe button at the bottom of the email? Did you have to really write the email saying, please do not email me anymore? So, you could hit the unsubscribe. We got 75 participants. I think that's the official threshold to get started with today's webinar. By the way, if you don't know who I am, if you're not a returning webinaree to the Magna program, my name is Peter Hecht. I am one of the co-founding partners over here at Magna Legal Services. That means I started the company with my partners, and I head up the sales, marketing, and some of the front office operations. And I also run our conferencing program. So you might be saying, what is Magna? Are they just an educational company? We're much more than that. And these folks here could tell you about that if they had time, but their topic is really important. So I'm just going to tell you what that is. What we do here at Magna Legal Services is provide end-to-end litigation consulting and support services. So that means that when you're taking depositions, collecting medical records, you're doing video services, you need an interpreter, a document translated. Who do you call? You call me, or you call one of my local sales reps at 866-624-6221. I had to put that in there, Ron. That's my little plug to Crazy Eddie Antar, because we've got an amazing attorney here from the Garden State, from Exit 9, Frank Cantelli from Hoagland Longo. Frank, he came in from New Brunswick virtually today. And if you think about New Brunswick, Crazy Eddie, who was the appliance king of the day, was his flagship store was in East Brunswick on Route 18, which my mom and dad took me to all the time. And those commercials were great because he had that little plug about, the prices aren't the same, we're just giving it away. And we're not just giving it away at Magna, we're charging you for it, except we are giving away the virtual platform for your depositions. That's right. How was that for a segue, Greg? So when you have a deposition, you don't have to worry about paying any extra fees for the virtual platform to conduct the depo. So all you got to do is call that number that I gave you. I'm going to plug it again at the end of the deposition, or at the end of the, that was a Freudian slip, at the end of the session today. I want to give a big shout out. If he's on the program, I want him to hit the chat bar to my longtime friend and sponsor, Brian Farrell from Wringler Associates. I haven't plugged a sponsor in a long time. He hasn't really written me a check yet, but I'm thinking he might want to write one for this particular plug. Brian and his friends at Wringler are the best leaders in structured settlements. If you want to get your deal done and make everybody happy, I would call the folks at Wringler and call up Brian. Everybody's chatting to Brian. It's a little bit of an inside joke. I'm always looking for Brian at my conferences, but he's the best sponsor. The least needs, and he's got the best reputation. So these folks here that we have are all from fine companies. Let's just remember that the opinions that they have may not necessarily be representative of the opinions of their company. I'll let them share that with you. Any opinion that I have about Magna Legal Services is Magna Legal Services. I'm the Magna Legal Services guy. So, Frank, I want to thank you for putting together the topic and the agenda. I am going to zip it. I'm going to hope that I covered all of my services so that none of my salespeople blast me. And I hope I didn't embarrass anybody. Thank you, everybody.
Peter, thank you very much.
Thank you, Peter.
Good job. So good afternoon, everybody. As Peter alluded to, my name's Frank Cantelli. I'm a partner in the law firm of Hoagland Longo, Moran, Dunstan, Ducas. I practice primarily out of New Jersey, but also New York as well. I've been in litigation for 30 years now. I have the gray hairs to prove it as well. You'll have to forgive me as well. On a personal note, my triplets just turned 17 yesterday. They're getting their driver's licenses today, and I'm waiting for the insurance premium. So, that's what I have going on right now. But other than that, I just want to say it's a privilege to be the moderator of this panel. We have a great panel for you today, and thank everybody for participating. Our focus here today is to talk about a very important relationship relationship between various entities, that being defense counsel like myself, a TPA, and also the carrier, and not to forget the client insured as well. What we want to do is just have an open discussion. I'll let the panelists talk for maybe about 40 minutes or so, 50 minutes. And then we want to leave about 10 or 15 minutes for your important questions at the end. If you have questions, please hit the chat bar and let us know. We'll also try to take them on a rolling basis. And as the title suggests, we want to work in some movie themes, some lines, some allusions to maybe some famous movies. So that's what we'll do along the way for the next hour or so. I just want to say, alluding to our title, Field of Dreams, we have built it, you have all have come, and we're very appreciative of that. And without further ado, I'm just going to ask the other panelists to introduce themselves, starting with Karen, and then Ron, and then we'll go to Greg.
Thank you, Frank. Well, I appreciate that. And going with our theme, my name is Karen Siebert. I work for Gallagher Bassett. I'm a vice president within the carrier practice. And as you can see, I am virtually at Wrigley Field. So we have Gallagher Way over at Wrigley Field, which is our field of dreams. Unfortunately, whatever you want to call this baseball season, we did not advance far enough. And I am in California. So I had high hopes when the Padres and the Dodgers were in, but the Dodgers are down 0-2. So much for that. But we'll see where we go with it. And looking forward to chatting with everybody today, talking about not only from the TPA perspective, but from overall, I was a general counsel within an insurance carrier, as well as, having experience here at Gallagher Bassett in our carrier practice team.
All right, I guess that's the handoff to me. I'm Ron Harrell. I'm with Catalina U.S. Insurance Services. We're the TPA arm of a runoff insurance operation that's worldwide. I started the day today at 6:30. I was the earliest riser. Our latest departure was 9:30 from Singapore. So we've got a worldwide platform. They call us the undertakers of the insurance industry. We take the liabilities no one wants and we handle them. So I've been in this business since 1981, which means I ought to retire at any moment, but I won't do that until we're done today. Greg, you're next.
Thank you for the platform. The name is Greg Duca. I am with Hallmark Insurance Company. I am their Chief Compliance and Operations Officer. I've been asked to be on this group with this great panelist because of experience that I have in working with TPAs in the past. I worked for a TPA company and also did a lot of work with TPAs on the carrier side as well. So looking forward to the discussion. I hope it's informative. And just for those who were curious, I am off of exit 3 on the turnpike.
Thank you all. So to get started with the subject matter, Ron, I'd like to just lead off with you. In general, what are the key attributes that you look for in selecting and working with TPA and defense counsel?
With anyone I work with, and particularly the TPAs and counsel, I really look for integrity. Do people do what they say they're going to do? Do they stand by their word? You have contracts, but contracts don't necessarily get the job done. You can always litigate. It doesn't get your claims handled. You want people with experience and expertise in the lines of insurance you're working with. As a runoff operation, we've got everything from professional liability to work comp, medical malpractice, all sorts of, trucking. So we need people with experience and expertise, and we look for that in our relationships. And then a professional commitment. Whoever you work with, you want them to be continuous learners. This business changes dramatically year to year, and we all have to adapt to that, and so people have to be willing to learn.
Very important attributes. I like to pride myself on communication. One thing that I wanted to get into later on, Ron, and you and I have worked together for years, which I appreciate, is what I've learned is it's just not about the trial result, the litigation that I do. Working with you over the years, I've really learned to emphasize the communication really among all of these groups, the TPA, the client insured, and the carrier, to bring it all together. I just wanted to shift though, because I think some of this from the attorney perspective is checking one's ego at the door. And part of that is we want to win every case that we have together, but part of that is dealing with bad news and how to communicate that. So I wanted to shift particularly to Karen. So Karen, you've had experience, like you said, on all sides of the issue here, really on the carrier side and the TPA side. What about communicating potentially bad news to the carrier? Do you do that yourself? Do you have counsel like me deliver the bad news? Is it a mix? What do you do in your experience?
Well, Frank, you were talking earlier about movie titles, and that one reminds me of the Bad News Bears, right? When you're coming in together and it's bad news. And I think regardless of whether it's good news or bad news, as Ron hit on, and we're going to talk about now and further, communications is definitely, number one. And so being honest and forthright, and to Ron's point about having integrity, there's a Jim Carrey movie, I think it's called Liar, Liar, where he's always trying to lie and it makes him tell the truth. Eventually the truth is going to come out. So, I like to make sure, like when we have our resolution managers and when I talk with our different teams, out there in the field, the supervisors, the account managers, the resolution managers, it's knowing the information up front and not having surprises, right? So if we can communicate proactively, explain where the case is along the way, make sure the file is documented, and hopefully Greg will jump in on this one, but make sure that file is documented, because if it's not documented, it's not there, it doesn't count. And then make sure you're getting those timely reports out, because ultimately when the bad news, it needs to be broken. If you're speaking with the insurance carrier, for example, with us, with the carrier practice, and we're talking directly to the insurance carrier, explaining here's why a reserve needs to be increased significantly, then let's make sure that we understand what we've done along the way, how we've communicated along the way, what the strategy is, making sure counsel is available, if needed, because ultimately we all have that tripartite relationship where we, in some ways, as a TPA, become a messenger, and we operate under the authority given to us by that carrier. But the defense attorney is also representing the underlying insured, who may have a different, interest. And then, doing your large loss reviews, making sure that you're being proactive, so that if and when it's time for bad news, I'm just we're very straightforward, we're very transparent. And then what did we learn from it? What's the postmortem? How can we avoid it again? And what's the next steps as a result?
Greg, I don't know if you want to speak to that.
I appreciate that. I can tell you that from the carrier side, getting surprised is probably the worst thing that can happen, right? Where you don't have appropriate reserves up, or you're getting some type of news about an arbitration or a mediation at the late stages, and you're not prepared for it. So carriers don't want to be surprised. Certainly, actuaries and your CFOs don't want to be surprised, especially when it deals with reserves and increase of numbers. So it's really important to have that open communication early on to make sure that you are communicating with the carrier effectively and as often as possible. As much as, Karen talked a little bit about having your file documented, that's great. That's an important quality aspect in terms of the actual file and how it actually is evaluated from all perspectives. But more importantly, it's all about that communication to make sure that no one is caught by surprise. And Ron, I'm sure you see that on occasion and have some thoughts on that.
Yeah, it's what I've seen in the bad cases is that you end up with TPA adjusters who are checking boxes instead of evaluating information that's coming to them. And that is frustrating from a carrier standpoint, to see them just going through the motions. By the same token, with counsel, we can take bad news, but as soon as you know something, we need to know if it's going to dramatically change the evaluation of the case. But the critical error I see is nothing changed, but we couldn't settle it, and so we're going to double our evaluation. If nothing's changed, then you double your evaluation. You can ask anyone who works with me. It causes me to hit the roof. I cannot stand it when that happens. So it is all about communication.
And I would double
Wow.
down on that, Ron. Sorry, Karen, but Ron, I think I met you probably trying a case years and years ago, 10 or 15 years ago. And I would say this primarily to the attorneys that are part of our audience today. It's never too late to deliver bad news. Again, part of my intro was, as an attorney, we have egos in these cases, right? We're going to win every case for you guys all the time. We're going to do our best, and we're going to take it to trial, and we're going to win. But things do change. And Ron, the case that I'm alluding to is, I remember it was about a $500,000 case, so it wasn't a trifle. And day one, and you had somebody monitoring the trial. Day one went great with jury selection and opening and the first witnesses. Day two was a complete 180, where the plaintiff put his mother on the stand and literally had the jury crying. The jury was in tears, which is not a good thing for us. And with the adjuster that was monitoring the trial, we had to report to Ron to say it wasn't a good day at the courthouse. We delivered that bad news, which was difficult, but I wanted to assure Ron and the monitoring adjuster that we still had a good defense, but it's important, attorneys, to give an honest read in terms of how the case is going, even if there's a negative witness or two. And to Ron's credit, we stuck it out. Even with that bad day delivering the bad news, we got a great result. It was a no cause in that one, Ron. So Karen, I didn't mean to cut you off. I just wanted to inject that portion.
No, you're perfectly fine, because I think we're all coming at this from the same, point of view, which is, it's not just a matter of checking the boxes, which is the, literal metric. Did you do this within 30 days? Did you do this within 10 days? Did you, notify somebody within X number of days? It's what was the substantive piece of that as well. So you have the objective criteria and the subjective criteria, and you bring those together. So whether it's a TPA, whether it's in-house claims adjuster, whether it's an attorney, if you're just documenting the file and having a 30-day report to say you have a 30-day report, our systems can actually tell if it's 80% the same language as the prior report. So, what's advancing this to move the case closer to resolution? So death, taxes, and every claim file gets settled at some point. How it gets settled, when it gets settled, that's what all of us and everybody in the audience is here to talk about today, because ultimately that relationship between the three groups brings it to conclusion, and hopefully we all live happily ever after, as they say at the end of every movie, right? That's what we all want.
So we talked about what I was going to label too, Karen, was the honey, I shrunk the kids, the bad news moment, but maybe shifting gears to talk about the dream team, because that's another aspect of what we want to present. Working as a team, defense counsel, TPA, carrier, all arm in arm. Ron, I guess I would ask you again to lead in this next topic. Most often, what do you see in your experience in terms of the problems of getting this team together, fielding these different entities?
Well, we've already talked about lack of communication, or the importance of communication. That's clearly one of the issues that you run into when things aren't going well. Sometimes you have divergent priorities. We've, as a carrier, you do run into firms whose business model is walk you to the courthouse steps and bail on you. And you have to be alert to that, particularly if you're new to the firm. And then TPAs, particularly if they're on time and expense, will sometimes leave files open a little bit longer than they need to be. So I think that's it. And then there's a lack of professionalism. You sometimes see, I've attended in the old days mediations where people were saying things in a mediation that weren't designed to lead to a resolution. It was designed to push people to the opposite side of the table and fight and fight and fight. And that creates issues if it's a case that as a company you want resolved. Now you have to find a way to get past that and get people talking again. So I think it's really the communication and making sure everyone's priorities are aligned.
I think that's very important, Greg. I don't know if you wanted to speak to that.
I did. I wanted to, I think it's a great point. I think what we found is, when we talk about communication, it's really about the priorities. So we found that our best success with counsel is those that actually put themselves in the position of the carrier and has the carrier's best interest at heart, and not necessarily being so dedicated and focused on winning the case and driving it towards ultimate resolution, right? Carriers appreciate when someone says to us, hey, this is a loser. You should get rid of this case. You need to settle it. Here's what we suggest to do. And let's put together a resolution strategy versus a trial strategy. We understand that you still have to have a trial strategy, but coming to us to try and prevent that is really what we value most from our partners. And that's what we look for when we work with counsel. And the same thing with TPAs, right? So when you've got a TPA, and we know that you have certain different pricing requirements, right? So if you've got a life of claim type of price, you want to make sure that they're not just leaving the case open, that they're doing something to be able to resolve it. So you're going to ask questions like, how many claims does the adjuster have? Or what are they working on? Why are they looking them every 30 days? Are they checking boxes? Which, again, will drive any carrier insane when they see people saying, okay, I've given you a 30-day report, a 90-day report, but nothing has gone forward in the claim to try and get it closer to resolution. Those don't help, right? The key is, as Karen said, 99% of these cases actually get resolved. The question is, how do you do it the most cost-effective way with both the TPA and the carrier? And that's really what it comes down to.
Well, and I think to your point, Greg, you know, the TPA, the attorney, the carrier, there's chemistry there, right? So just like any good baseball team, football team, you pick the team you want to pick. But the chemistry and that open communication with each other is so important, whether it's good news, bad news, whether it's just as the case is progressing or as the file is progressing. And, you know, I'll give the Tom Cruise reference, right? I think it was him when he said in A Few Good Men, you can't handle the truth. Well, no, we can handle the truth. But you have the right resolution manager, the right claims professional who is negotiating, maybe collecting the information, doing the investigation. That might be a different person than the one who's negotiating the claim file at a certain level. That might be somebody else who's then explaining to the customer and the carrier, here's what we're doing, here's our plan of action. And then the same thing when it comes to the attorneys, right? So, you know, you have some people in baseball who are, you know, the starters, you have some who are the relief pitchers, and you have some who are the closers. And so when we're looking at counsel, we use Gallagher Bassett uses something called GBLMP. So we're measuring our legal professionals and we're working with them to understand the different jurisdictions, to understand who we need as defense counsel, negotiating counsel, and then for 5% or fewer claims, who's going to be trial counsel? Because, you know, just like pitchers, not every pitcher is the same, not every attorney is the same, and they bring different skill sets to the table. Just like we wouldn't put a workers' compensation professional into a major case unit handling a transportation fatality or a collision. It's different skill sets. And I think that's something that all of us, you know, in all these Hollywood squares up here are really good at making sure we get those right people in the right seats.
What I would say too, is, and it basically goes hand in hand with what you said on the other side of the equation, coming in as defense counsel, the movie quote I would use is you complete me, but I look at that as I complete you guys. And it's really taken a long time, much of my 30 years, again, to get over the ego of trial attorneys want to come in, they want to win the case, they want to get a result. And like you said, Karen, we all know that less than 5% of the cases go. Look, every case I have, I'm thinking about what's going to happen at trial, but I've realized over the years, and again, another message to the attorneys is never stop growing in this business. I've been at it for 30 years. I probably learned more in the last 5 than I did in the first 25. And that is why communication is critical. One carrier said to my firm a few years ago, you know, results aren't everything. We kind of scratched our heads, but I think we've learned that, particularly in the age of technology, that reporting is important. And particularly early on in the case, as I think Ron alluded to, we need to learn what your goal is in the case. And if it's a case for whatever reason, business or otherwise, exposure, you want to resolve, we have to then act accordingly. And we know that case probably isn't going to go to trial. Your timeline is more important to you, saving on defense costs. And we have to learn to adapt. The other thing that's been drilled into me very well, and this is a great discussion for it, is TPAs have the reporting guidelines. The carrier has their reporting guidelines. And I would say again to the attorneys, I've learned they exist for a reason. If you don't do that, you can get great results. But if you don't follow the guidelines, it's going to be bad news. The other thing I tell young attorneys in my office is, again, you can be going out there winning motions, writing briefs very well, but if nobody knows about it, if you don't check in with the carrier and let them know, it doesn't mean anything. So while I also try to follow the guidelines, what I like to do on a periodic basis is give quick updates. If I have a case for Ron and there was a big deposition, I may not be able to summarize it in the next few days, but I'll email him right away when it was done, saying, Ron, we took the deposition of that key expert witness and it went good, bad, or sideways for us, and here's the reason why, but it's a case changer. And finally, my advice, and again, it's what I've learned from the industry professionals, is I try to weave in what the legal event, the deposition, the motion, whatever it is, what does that mean to your bottom line in the case? Again, was it a good day? Was it a bad day? Does it change the exposure? And I try to do that even, within the timelines of the reporting requirements. So I think it's a good discussion. Ron, I'm glad you kicked it off in that regard. I think we're all on the same page that really it's just recognizing what the goal is, whether or not it's going to change, and from defense counsel's perspective, continue to check in on that goal.
And I think one of the issues that I see is that from TPAs, from the people who report to me, from our defense attorneys, is an unwillingness or a hesitance to weave in their experience on these cases. Most people involved in this business have handled, if not hundreds, thousands and thousands of these cases. And you know what the plaintiff's going to do on them. So use your brain. What are they going to do to me? Our counsel should know the opposing counsel and their standard practices. They're going to get a life care planner. Well, let's start planning on that. How are we going to counter it? What do we think it's going to be? And start weaving that into our exposure analysis instead of, saying, well, they gave us a life care plan of 5 million, so my 500,000 evaluation is now 2.2. Well, we all knew they were going to get a life care plan. So let's start weaving that in early. And that gets to Greg's point, don't leave us with short reserves, because that's embarrassing. It's embarrassing for any good claim professional to be caught with their pants down and nothing's changed. So.
Again, changing gears, I know it's something that I discussed with Greg a little while back, but in terms of the TPA piece of this, Greg, I know one thing we've talked about and you wanted to address here today was the importance and the value of the TPA audit process and how this helps the team be more cohesive. Could you just talk about that for a few minutes?
Sure. As Ron said earlier, it's important to have a relationship and integrity with your TPA. Those things are critical to have a relationship, to knowing that they're professional, they're doing a good job, they've got integrity. That is one side of the equation. The other side is you now need to be able to hold them accountable, which is to check and make sure that they're doing what you've asked them to do. And that takes place in a number of different ways, but probably the best way is really to have an audit function to be able to audit your TPA. And the types of audits you could do, it should have really two aspects to it. There should be a qualitative aspect and sort of a quantitative aspect. By qualitative, it would be you're looking at a file, you're looking at seeing whether there are gaps in communications, whether there are any reserves that were not put up timely, whether they're using appropriate vendors, whether the file is properly documented. Just a number of things that you can measure to see how well they're performing. And then from the quantitative side, you kind of want to look at how many cases does the TPA have? What is the closing ratio of this specific adjuster? Do they have any type of 30-day closing requirements? What's the age of the pendings that they're currently handling? Have they had any new suits recently? What's their current pending suits? So there's that type of data that you want to look at, and you want to be able to evaluate just to see how well they're performing. And at the end of the day, you'll be surprised that maybe people that you thought were doing a good job may not fit that when you look at the metrics, or vice versa. At the end of the day, that's a critical part in being able to evaluate the performance to make sure that they're holding up their end of the bargain and they're meeting your expectations, because it's all about meeting with those expectations. It would be unfair if you started to measure them without giving them the proper guidance and requirements and guidelines that you would want from them. But again, from my perspective and the carrier side, you want to make sure that they're doing the right thing. And that way you have an opportunity to be able to adjust that. So if you find that they're not closing cases or certain adjusters aren't closing them as timely as you would like, have a conversation with them. You tell them what your expectation is. Tell them, give them examples of what you're looking for and how you want to be able to resolve it. And those type of things are going to correct behavior and develop and continue that relationship so it becomes positive as opposed to going in the other trend.
Yeah, and I would say from a TPA perspective, not only do we welcome that, but I think you've hit on a couple of things there, Greg. I think first, and Ron, the same thing, and we've all kind of worked together over the years in different ways. But, you've got the leading indicators, right? So you have certain metrics that are leading indicators telling you where the file is going. You got the lagging indicators. Once the file is closed, where was it, what happened, and how did it get there? And then you've got, open file reviews, closed file reviews. We love doing stewardship reports, large loss discussions, understanding what the triggers are that you want to know. For example, when a case is going to be reserved for change of 25,000 or 50,000, or if you want to know if an offer's been made, and maybe the philosophy is make an anchoring offer. We want to put an offer out there first. Because, if you wait for a demand, guess what? It's going to be a policy limit demand. So, as you and Ron were just talking about, why are we acting surprised if we wait for a life care planner, to come in? It's the same thing. If you wait for the demand, and you've got a fatality or quadriplegic, you may as well just wait for the policy limit demand. So why not be proactive? Or, at the very beginning, Peter was mentioning Wringler. Wringler, with their structured settlements, they probably know some of the plaintiff attorneys or they've been there. So get advice from them as well. We're all in this together to get this file, resolved.
We've got a question from the audience directed to Karen, and it says, do you encourage panel counsel to talk to each other about what they are experiencing with plaintiff counsel to strategize against social inflation and nuclear verdicts? Do you have some comments on that?
One of my favorite topics, right? Nuclear verdicts, the reptile theory. Absolutely. And I think on that regard, for some of our clients, we actually have clients where we bring panel counsel together. Right now with COVID, we're not sure how we'll do it, but we'll bring all the panel firms together for a particular client to say, what are the trends you're seeing in a particular jurisdiction? What are you seeing, for example, in Eastern Texas? Is it still one of our judicial hellholes? I live in California. We're an entire judicial hellhole. New Jersey, you guys in New Jersey and Pennsylvania, you've got your share of issues too.
East Texas is still bad.
Yeah, exactly. So absolutely. And making sure that the firms talk with each other and that we offer transparency with regard to the firm itself and how we're measuring them and how we think they're doing. We're not looking to compare two different firms in two different jurisdictions handling different kinds of claims, right? So we're looking at outcome-based, we're looking at the fees and the costs, but we're also looking at what is the total cost of risk for that insured, for that carrier, for that self-insured on our risk management clients, because that's all part of it. So thanks for bringing the question up, Ron, but we definitely want the communication happening because guess what? The plaintiff attorneys are getting together. They're talking about it with each other. And we've got to make sure our defense firms know how to file motions in limine to get rid of reptile theory right up front, or to understand how to prepare a 30B witness to make sure that they know, don't fall into the yes, 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 and what's your duty and what's your standard you're being held accountable to. So we're more than happy to have those discussions.
And I think it can be sometimes difficult to get two panel counsel together. In a virtual world, it's not so much. And I think in large part, my firm is always willing to work with the other firms, particularly in New York and New Jersey, defense firms that we're familiar with to share information for everybody's benefit. And there are some great organizations, particularly in New Jersey, that help us do that. I think even a more effective way is, I know panel counsel would be more open to this on a one-on-one basis. So Karen, you picked up the phone or you emailed me an opinion on something, and I know I've done this for some of our participants too. Even if the case isn't in suit, I will give you an evaluation, and I don't take it as, you're comparing me to other defense counsel. I think that may be even an easier way to do it, is just deal with one defense counsel at a time. And that is a good quality control check on your end, and maybe counsel would be more willing to give an open and honest opinion that way. If you can't get counsel together in a group, or as a couple of defense counsel together, but always, even if the case isn't in suit, if anybody picks up the phone or communicates with me, I will give an honest opinion within the bounds of what I know about the case. Karen, in those situations where there's not an alignment with the TPA, the defense counsel, and the insurance carrier, have you, in your experience, what, if any, creative things have you done to get the issues brought to the table or the case to resolution?
Yeah, so some of my colleagues know this story, but we had a very interesting case when I was a chief claim officer, where a demand came in right below policy limits. So that way, if we didn't settle it, we would potentially be held in bad faith, right? So that's one of the strategies that comes into play. And we made a reasonable six-figure offer to try to show that if we were getting set up, we did put real money on the table. And we couldn't get the file resolved. We were at odds with the insured saying, get this settled, get this settled. I don't want to be bankrupted if this doesn't get resolved and it blows through the policy limit. And what we did was we actually, and this is kind of where Magna comes into play too, in this situation, we actually called upon Magna and said, we'd like to get 2 focus groups involved, and we'd like to actually practice with our counsel, practice our opening argument, practice closing arguments, do what Magna calls a clopening, and we use different words. We use different words to describe the vehicle that was involved and to see how the jurors reacted, because you can see them turning red, yellow, green as they're reacting to the words you're using. And then to watch them deliberate was amazing. And we were all in a conference room, and we were able to have other people who weren't even in the case in the conference room watching, so that it would educate our claim professionals as to how a jury thinks. And when one of the jurors says, yeah, but I feel really bad, it's like, oh my goodness, the movie 12 Angry Men come, to mind. It's like you're trusting 12 people, and here's how I'm feeling. It's not a matter of how you're feeling. What do the facts say? What were the jury instructions that were given by the judge? What did we present? And where is this going to end up? Now, ultimately, the good news is that both sets of juries came in with defense verdicts. And so ultimately, we did go to trial, and we did get a defense verdict. And that case has been appealed several times. But, using that and putting good money on the table and making the investment to get that jury verdict research done, or to use jury confirm or the other tools available, really, really served us well. I'd love to hear from the other panelists, like if they've used it. But I can also tell you that, when we're handling legacy portfolio claims, it's always important, by the way, to understand, there's not a bottomless money bag out there. This isn't Richie Rich. We are not the bottomless pit, and you can just keep throwing money at this thing. But especially in the legacy market, where a lost portfolio maybe has been done, or a commutation's been done, and there's a limited amount of money, and actuaries have made their estimates, we need to be very aware of that as we're working through the files.
Yeah, I think that's a good point. Particularly legacy space is where we make our money here, and we have accepted a certain consideration for taking on all those liabilities. So we are not, these claims can be the money pit, and we need to watch for that. But by the same token, it makes us also averse to significant nuclear verdicts, because one bad verdict in one of these books can take the whole thing down and turn it unprofitable for us. It's funny, I heard a comment, I think it was from you, Frank, about how less than 5% of cases go to trial. And we try a lot of cases at Catalina, but it isn't anywhere near 5%. Probably closer to 0.005% actually get tried, the rest of them resolve. And so that leads back into How do you leverage a case to get it to resolve? And the jury confirm. I've used it a number of times. I've used mock juries. I don't trust mock juries that much on values. I've found that if you anchor to the values they give you, you're asking to get blown out of the water. What I do like them for is allowing counsel to refine their arguments to know what works with the jury so that they can use those if we do get into trial.
Ron, I think that's a great point from counsel's perspective. I tried a case years ago against the plaintiff's attorney, and it was a wrongful death case, again, not a trifle. And it was one of those, what I would call black and white cases where on the defense side, we had a great liability defense. If we lost, the case would have been worth a lot of money. And all the plaintiff's attorney kept telling me before and during trial was, well, you know, we took this to several mock juries and we got verdicts ranging from X to Y. And I said, well, that's great, but that's not our jury. And you make a great point that sometimes we get stuck in the results, which it's a good function of doing a mock trial before the actual thing. But in that case, the plaintiff's attorney was too stuck on those results. He was intractable. And guess what? The case went to trial. And after a 2-week trial, we got a no cause. So you're exactly right. I would say that and something that Karen mentioned in terms of jury verdict reviews, I've actually been going to a lot more. And again, Ron, great point. I can look at what the recent cases are in New Jersey about values to give you a range. But I think what we're talking about here is each case is somewhat different, but at least that gives us a range of highs and lows, and we can compare, you know, those cases. I think that's another good tool as well, as long as we just don't think that that's going to be our absolute bottom line and we're completely married to them.
Yeah, I think from a carrier standpoint, I think I just jumped over Greg here, but from a carrier standpoint, we're not asking for perfection. You're going to be wrong. Our reserves are almost always wrong, but hit the fat part of the bell curve. You know, don't give me worst case, don't give me best case. Let's hit the middle of the bell curve so that, you know, we're within plus or minus 15%. And I think that's doing pretty good for any claim professional or any lawyer.
You know, and from the carrier perspective, earlier is better, right? So I know Ron had mentioned earlier that, you know, you don't want to find out at the end if nothing's changed and all of a sudden the value of the case is sort of doubled, right? You don't want that at the last minute within the last 30 days because that doesn't do, you know, the actuaries and accountants any favors, right? They need to know earlier is better. So we want to know as much as possible, as early as possible, even if it's your worst case scenario. Again, our preference is not, but even so, the better we're able to plan for it, the better we're able to make a decision on that, be it from a reserving standpoint and also from a decision-making standpoint. So that relationship has to continue to be open and honest, and there has to be that dialogue. And, you know, like I said earlier, you know, tell us the bad news if it's bad news. Tell us the good news if it's good news. That's a good thing too as well. Yeah,
we got another question here, Greg. Maybe you can field this one. And it says, on a high exposure case, what percentage of the key discovery do you want your hired trial lawyer to handle? And then it says, Karen, does your GBLMP, whatever that is, look at this issue?
No, I'm gonna give it to Karen first. I'll jump in after. Go ahead, Karen. I'm curious how that play out.
Well, I was going to answer something that the three of you were talking about earlier, and then I'll answer the GBLMP. You had mentioned earlier the experience that the resolution managers, whether it's inside or at a TPA, bring to the table, right? And so one of the tools that we have is called Waypoint, where we have, you know, obviously we've been in business over 50 years, but, you know, we look at decades worth of data by jurisdiction, by kind of injuries, by the different comorbidities and workers' compensation, for example. And we're looking to see, based on that information, where do we think this case should be within 3 months, 6 months, you know, a year down the road. So that, to your point, Greg, we're setting a most probable outcome, but then we're bringing that human element and all those years of expertise of the claims adjusters to the table to say, yes, but here's how we can get this resolved, or here's a strategy to utilize, or here's the, you know, SIU or the fraud that we found, or here's social media showing, you know, what this person's been up to. So the allegations really aren't true. And then trying to put all that together so that you don't have to take every single deposition of every single witness to the other person's question on the Q&A. You know when you have enough information. You know, you know it. You don't need to exhaust every single dime out there to go after that. When you know it's bad, let us know. Tell us what we need to hear, not what you think we want to hear, right? Because we need to make sure this is getting resolved. And so the litigation management and then the law firm measurement program, the LMP program, takes all that into account. And we're looking at not only the outcome, but, you know, why do I need a budget through trial if we're going to less than 5% go to trial? So show me the budget by the different phases. Show me what you intend to do along the way. We have objective measures like that. We have subjective measures as to, are you openly communicating? Are you telling me this is a winner? And then 11 months in, and after all your bills, you tell me, resolve it on the courthouse steps. Or changing counsel because you say, well, I can't try this. I thought it was going to get resolved. Now I need to bring somebody else up to speed. So all those different things are coming into play when we're looking at the law firms. And it's not just a matter of what is the hourly rate, right? It's what's the total spend on this file to get the desired outcome. We do a lot of alternative fee arrangements, you know, with our firms, and we welcome those discussions on the different, you know, client basis so that we all know we're fighting for the same result.
And I think from the defense attorney's perspective, I know I pride myself on wanting this to be a win-win. Again, I use the Jerry Maguire, you know, you complete me. That's the part that I want to be. I've learned over the years, I don't want to be the element of this that has to be audited or has to be reminded of things. I think, and I tell my associates this, we're doing our job when we're over communicating things. I know that's been an overriding theme of this, and I've never been gigged in an audit or told not to over-report on a case. Karen, you touched on something great too. I think the worst thing that we can do as defense counsel is overpromise and underdeliver. And I've seen that, you know, with other firms in my day. That's the last thing that I want to do. Like I said, we want to identify the early resolution. And if we know that we're going to battle in a case, then prepare the case at each one of these discovery proceedings as if the case is going to go to trial. What is this deposition going to do for the case at trial? And always remember that when we're setting up our outline for questions. And I think this goes hand in hand with the question. I can say in the right type of case that I'm sent, where I know that I'm being retained as a partner and I'm responsible for the case, I want to take as many depths in that case as possible. I think it just makes a huge difference to have seen the plaintiff or see a witness eyeball to eyeball to be able to report. I can't tell you what an extreme difference that makes. And I've had cases, and Ron knows this, where we've taken over from other counsel a week before trial. That's kind of fun too, but it's always better to have taken the discovery and to be able to give you the evaluation of the witnesses being in the same room, or at least, you know, virtually on the other end of the camera, as the case has been the last 6 months.
Greg, do you have an opinion on that issue? What percentage? Holy hell.
Who let the dogs out?
Ron, what was the issue again, if you don't mind me asking?
I'm sorry. It's what, on a high exposure case, what percentage of the key discovery do you want your hired trial lawyer to handle?
You know, the critical stuff, you want them to handle all of it. I mean, the most critical pieces to it. Do they need to do the basic, you know, paper discovery? Some of the depots, probably not. Certain depots, you do. Certain motions, you want them to argue. But it's critical because if you're going to try the case, then you want them involved. If you don't think you're going to have it go to trial and you're positioning it for settlement, then you need to have a different strategy. The key is the earlier you be able to set the tone for what you want the outcome to be, the better off you can manage both how you handle the claim from the TPA side and how you work with counsel. You know, and that's not to say that you may say you're positioning this to settle and plaintiff's counsel just being unreasonable, their plaintiffs being unreasonable. Then you have to have an alternative background approach. You can't be just left hanging there saying, oh, guess what? We're now going to mediation and we haven't taken these depositions. That's a bad thing too. So You just need to be prepared. But the key is, my estimation, is having that strategy set early on so you know where the outcome's going to be.
Yeah, and again, the communication. If you've got counsel isn't going to take what we would think is a key deposition, then a call. This is why it's not going to happen this way, and this is who's going to do it and why. I think that's the main thing.
Yeah, and Ron, you took the words out of my mouth with that. I would say from an attorney's perspective, what I think the A+ answer is, I want to take the depositions normally, but I have to know on a cost-effective basis, like Greg, you alluded to, maybe it's not a key witness, but checking in ahead of time as an attorney to report to both the carrier and the TPA to say, hey, I want to take this one, or do I have your authorization to use this associate, and here's why. And doing that ahead of time rather than sending somebody, you know, and have them do a bad job and report it later is problematic.
Yeah, Frank, I don't know if
Frank, one of the questions that just came in. Okay. Oh, sorry. One of the questions that just came in deals with the claim professional and the attorney talking with one another about reserves and where the claim professional should set their reserves. And I think that's a good one for all of us as we're coming, you know, towards the top of the hour here. But rather than talking specifically about here's where you should set your reserve, I don't necessarily think that's the way the question should be directed. I think it's what's the range? And we may have hit upon this a little earlier, but what's the range in this jurisdiction for these injuries with this kind of comparative or you know, negligence, you know, issue, or if it's statutorily required, or if you're dealing with New York labor law. I mean, there's different things in different jurisdictions that all come into play. And therefore, what's the you know, the low, the medium, and the high? And then the claim professional needs to talk through that, especially with the client, on what's their philosophy. Most clients say, set it to the most probable outcome, right? And then you're factoring in what are your expense reserves to go along with that. And should you continue to put money on the expense side, doing depositions or experts, et cetera, versus going ahead and trying to get the claim resolved. So we try not to put counsel in the middle of that kind of a decision. One of the things that I know, it's not necessarily my role now, but our claim professionals out there, you know, we're not sitting there telling counsel, we've only got this reserved at 100, so you got to get it done within that reserve. That's not the discussion. The discussion, and I'd love to hear from all of you guys, is really, you know, what is the value of this claim in this jurisdiction with these facts and circumstances, and how can we get it resolved fairly, quickly, efficiently, right? And avoid the surprises, avoid the negative outcomes, because that's what we've just talked about. None of us want to see that. As opposed to telling counsel, well, you have authority to settle this up to 100. Well, meanwhile, you know you have 250 reserved. So why are you putting them in an awkward situation? So I'd love to hear from the other folks on this, on how we would respond to that question.
All right, I'll go ahead and go. If one of my claim professionals calls you and asks, where should I set my reserve? Your first response would be, let me think about it. I'll get back to you. Pick up the phone and call me. I've got a training. I should never ask what their reserve should be. Yeah. Now, each company sets reserves differently. And so as a defense attorney, you don't know what the company's reserve philosophy is. All you can advise us on is what is the range of exposure for this case in the jurisdiction based on the facts. But that's a tightrope for you because you want to maintain your relationship. So good luck with that, but let me know. Go ahead, Greg.
I mean, I agree. The question is, you know, what is the value of the case if you're going to settle it? What's the range? If you're going to, that's the discussion you have. It's not about reserves. That's a carrier decision. That's a carrier to decide how they want to do it. Their decision could be, we're going to put up the policy limits or not. However they do it, it's really about the carrier. So that's not a discussion that we typically would have with either our TPA or our counsel.
We're aligned here, and I'm glad to speak to it from the defense counsel perspective. I don't know that I've been asked it directly, Ron, or anybody that you work with, certainly, but other carriers, you know, particularly younger adjusters have asked, or they've started to tip me off on it. I will tell them respectfully, I don't want to know that because I look at that as completely divorced from what I do. And in fact, it may infect what I do. I mean, I definitely want to get a good result for you folks, but you've hit it all on the head. In my world, it's what's the settlement value, what's the exposure, basically, should we try this case or not if it has defenses? That's my role. And within this, Karen, I think it's a good question too, because to me, there's a subset as well that I wanted to address, and I know we only have a couple of more minutes left, but it's in terms of settlement value too. I'll be asked open-endedly, well, what's it going to take to settle this case? And I just wanted to, in the context of this question, point out that's somewhat of a loaded question too, because I will always give you what I feel is objective settlement value. Karen, to your point, worst case, best case, here's in the middle of where I would recommend that you would settle, nothing to do with reserves. But we all know, particularly in the state of New Jersey, there are difficult, and hard to work with plaintiffs' attorneys who are going to swing for the fences. They're not going to give us demands until close to trial. And so what I think they're going to settle for is much different than what I would recommend that you settle the case for it. And on the defense counsel side, I think that's actually the more difficult issue. I don't know if any of you wanted to touch upon that, but
Frank, real quick, that's very different at exit 9. Exit 3 is a little bit different. So,
There's one other question here, and it's how do insurance companies and TPAs meet new panel counsel? And I can tell you, I don't mind people reaching out to me. We're not presently adding to panel. We need to do another transaction in the US to do that. But I don't care if someone sends me an email or hits me on LinkedIn or whatever. That's just fine. And that brings up the movie line, so you're saying there's a chance. I don't like having too many attorneys in one jurisdiction. I like to work with people I know and trust, but I will work with young people. I will work with firms that we haven't worked with before, as long as they're willing to learn about what Catalina is about and what our expectations are. I don't know, Greg, if you've got anything on that.
No, I would agree. I think it's the same thing. It's really about getting relationships that you have, building new ones, and really having counsel understand what your expectations are. That's probably the most important thing out of all of them, because you've got a philosophy about trying, about settling, about how quickly you want to settle, when you want to make the offer, those type of things. And the more firms are in tune with what the carriers want, the easier it is to sort of be able to meet their expectations, but then again, only leads to more business. I mean, we've had very good relationships where, counsel looks out for us and says, here's a better way to do this, more cost effective. Here's something that you should settle and not try. So they're looking out for our well-being, which only, again, strengthens the relationship.
I will tell you, in New Jersey, you're probably out of luck. We're pretty locked in.
that's what we wanted to hear, Ron. That's exactly what we wanted to hear. Thank you. But on behalf of my firm, we're always, looking for new business as well.
They're just jealous of not being in the Garden State, Frank. That's it. That's the whole idea.
And now that I see Peter, I was going to close it with the movie line of, Adrian, we did it, right, from Rocky. So we got through this okay, Peter, right?
You guys did fantastic. I mean, I really think you built the field of dreams, but who am I to say? I'm just a sales guy from New Jersey. Seriously, you guys were great. Frank, great moderating. Karen, you're a repeat star performer. You should get the Magna Oscar. And Ron, I like your movie quote. I like yours, Frank, but I like yours even better. Great movie, by the way. That should be some good trivia if anybody's wondering what movie it came from. And Greg, if you want to know more about Greg, go onto my website or click on my LinkedIn profile. He was the feature of the one-on-one Magna Spotlight in our Magnify pandemic special newsletter. I think you should check it out. It's a great way to get to know people. And he shares some really deep secrets about my golf game. Seriously, everybody, I don't really golf. I just sit in a golf cart and play on my phone and smoke cigars.
Don't forget the cigars. Don't forget the cigars.
The cigars. It's yellow teeth, right? I'm gonna get them whitened really soon. Two major announcements, just in case you own a Peloton, Ron. Tomorrow at 4 p.m., a bunch of my enterprising sales folks are raising money for Children's Hospital of Philadelphia by doing a group Peloton ride. So if you want to learn more about how you can participate, you don't have to donate any money. You just got to donate 30 minutes of your time to pedal away, and call us at 866-624-6221. And don't ask for me. Ask for Jordan, the Jess, There's no registration fee. It's free, and it's a lot of fun. The next thing I want to mention here for all of you, if you're thinking about like, hey, I've got a lot of webinars to go to, I've got some things to do, but you know what? They all kind of seem the same. Mine are a little bit different, right? I mean, you've got me, plus you've got Ron and Karen and Frank and Greg. I've got something coming up. I think it's November 5th. Don't hold my feet to the fire. It's either the 4th or the 5th. We're raising $1,000 for Children's Hospital of Philadelphia. We're going to do a 30-minute Q&A on some newfound topic about COVID-19 and litigating. I'll come up with that. 30 minutes of that. And then 30 minutes of competitive eating. That's right. Me and 4 of my top sales guys are going to compete to donate $1,000 to the Children's Hospital of Philadelphia. We're each going to be stacked with 25 White Castle cheeseburgers, a large Coke, and 10 minutes to go. It'll be hosted by the not real Guy Fieri. It's going to be a lot of fun. No CLE credit. There's no CLE credit here either, but it's going to be fun. So listen, schedule your next deposition, folks, with Magda, free of charge, no charge for the virtual services. And Ron, Frank, Karen, Greg, thank you, Gene, thanks for putting this together. And I'm out.
All right. Thanks a
Thank
lot.
you, everybody.
Thanks for having us.
See ya.
Competitive eating. Come on. It's a good idea.
I should just give you the money and avoid the White Castles, man.
How's that? Show me the money. Big
There you go.
reference
Funny.
in.
I'm
I got a
telling you,
movie
I
reference
can't
in.
wait. I could usually do about 10 White Castle cheeseburgers in a regular sitting. So, you know, all my sales guys, they're youngsters. They think they can take me, but like, I'm like, the proof is in the belly. I could do 10, no problem. 20, I'll be pushing it. 25, you put your money on me.
All right.
All right. Thanks, guys.
Thank
Bye.
you.
Thank you, everybody. Appreciate it.
Take care, everyone.